So now, without further delay, let's begin today's event, sponsored by LexisNexis Risk Solutions and hosted by Payment Source. It's my pleasure to introduce your moderator for today, and that is Michael Sisk. Mike, you have the floor.
Thanks very much, Greg, and I would like to welcome the audience once again. We are very grateful that you've chosen to share some of your busy day with us. We know that your time is valuable, and for the next 60 minutes or so, we will make every effort to make every minute count. Once again, our topic today is how to navigate the new environment for liens and judgments. And my name is Michael Sisk. I'll be your moderator today. I've been a New York-based journalist for about 20 years, and I've had stints as investor editor at Red Herring and editor-at-large at U.S. Banker. And my articles have also appeared, besides American Banker, of course, in Barron's, Crane's New York Business, Inc., Institutional Investor, Strategy and Business, and Worth. And I am very, very pleased to introduce our three excellent speakers today. The first is Zach Tondre. He is Manager of Market Planning at LexisNexis Risk Solutions. Prior to joining LexisNexis in 2017, Zach worked as a credit union executive and a mortgage banker. Joining Zach is Jason Horsley, Director of Market Planning at LexisNexis Risk Solutions. Jason has more than 20 years of experience in the credit and collection industry. Prior to joining LexisNexis in 2006, Jason worked at Encore Capital Group and Capital One. And rounding out our panel today is Nick Larson, Business Development Manager at LexisNexis Risk Solutions. Nick has 30 years of experience in and serving the mortgage banking industry. Prior to joining LexisNexis in 2005, Nick worked at Freddie Mac for over 18 years, and we are very pleased to have all three gentlemen with us today. And just before we jump into the real meat of the discussion, I wanted to reiterate just two things that Greg mentioned at the top. We do have time at the end for Q&A. We usually have about 10 or 15 minutes or so. You can put your question into the queue throughout the hour as the spirit moves you. You don't have to wait until the end, so please get your question into the queue, and we'll make every effort to get to it in the time we have today. If we don't get to your question, if we run out of time because we've got lots of great questions and lots of great content, which sometimes, that can sometimes shorten our Q&A a little bit, fear not, we will follow up afterward. So, please ask away. We very much want to hear from you, and we will address your question either in the time we have with us today or shortly thereafter. And we also have a couple polls, and I always encourage 100% participation. We do share the results live with everyone here, and it's really a very nice way for everyone to see where everyone else stands on the issue that we've come together to discuss. So please weigh in on those polls if you can. And I think that brings me to the end of my little spiel here. Let me officially turn things over to Nick, who is going to run us through the agenda and really get things rolling here. Nick, please take it away.
Thank you, Mike. Good afternoon, everyone, or at least I think for most of you it is afternoon now, and thank you for joining today's webinar on how to navigate the new liens and judgments environment. During the next hour, we intend to cover three key things. One, to provide you an overview of what changes are coming to credit reports, when that'll happen and why. We'll also review what impacts we expect to see in the credit risk, collections, and real estate markets as a result of those changes. And probably more important to this audience, we'll also recommend areas of focus, next steps that you should look at to take in response to those upcoming changes. So let's start with really the story. It all starts with the credit report. And as most of you know, the credit report really contains three key pieces of information. One is the basic consumer information, trade line information, which most people really think of as the credit report itself, which shows information about credit cards, car loans, how much of the credit has been used by the consumer, and just as importantly, what is their history in making those payments in a timely manner. And then the third piece of that really gets into significant credit events that are also included in the report. For example, bankruptcies, liens and judgments, etc. So as the slide that you see here shows, you can have a tax lien or a judgment that comes as a result of a civil action being recorded by the courts. And that information, that record that is recorded and now public record, may actually be spin on personally identifiable information, as this example shows John Smith in Sampletown. Well, with that limited amount of information, that record could actually apply to multiple people with similar sounding names or similar names in that area. Or you can even have the example of a junior-senior issue where ultimately the key question is, that document, who does it refer to? And to the extent that linking is not able to be solidified to a key person, then you're looking at creating processing delays around consumer transactions and ultimately frustrating them. And to that point, consumers have complained to their states about accuracy issues regarding the credit reports and what they feel are resulting impacts in terms of their ability to access credit, housing, employment, et cetera. And starting with the state of New York, and 31 states' attorneys generals filed a class action suit against the bureaus to drive improvements to the consumer credit reports. This resulted in a settlement between the states and the credit bureaus referred to as the National Consumer Assistance Plan, or NCAP. Now, as a result of these changes that NCAP is driving, they've announced that as of around July, the beginning of July, liens and judgment data will only appear in credit reports if at least 3 of the 4 personally identifiable pieces of information about a consumer are included in the record. And that includes social security number, their name, date of birth, and address. And based on the Bureau's own analysis, they expect that the reports will no longer contain, after this upcoming change, approximately 50% of the liens and 96% of the judgments. So this means that the upcoming reports will no longer have most lien and judgment data, and most of the impacted consumers are expecting to see, on average, a 10 to 20 point boost in their credits in the consumer credit scores. And based on some of the analysis that you see, some of the movement is actually more significant than that and really makes the difference in terms of a consumer's eligibility for certain loan programs. So at this point, let me turn it back over to Zach to start us off with a poll question and then go over the credit risk impact assessment. Zach?
Hey, this is Mike. I'll just jump in and read this question first off and just get everybody kind of rolling on this, and then Zach, you'll probably want to weigh in on the results. But so everyone, this is our first poll, as promised, and it's pretty straightforward, yes or no. So, are these changes the result of new regulations? And simple yes or no question there. I'll give everyone just a moment or two. I don't think it's going to take too long for you to weigh in on that question. So give everyone another moment or two, and we'll bring Zach in on this question. Okay, that's probably enough time. So let me go ahead and share the results. And there we go. So pretty kind of a 60, 2/3, 1/3 split there. Yes, 64.1%, and no, 35.9%. So Zach, what do you make of those results?
Yeah, so it's very interesting to see where we are here on these results, and speaks to a lot of what we've been hearing from our customers and just the market in general. That almost 64% of you are thinking that this is a regulation, but in fact, NCAP is not regulatory in nature. The National Consumer Assistance Plan is something that was purely crafted by the bureaus in a response to this 2015 settlement that Nick mentioned earlier. This plan belongs to the bureaus, both in action and accountability, and shouldn't be misunderstood as a regulation on the industry. This is not focused on participants in the industry, and this really has more to do with changes that the bureaus are making than changes that need to be made by the industry. Talking a little bit about, we continue to hear folks talking about complying with this, quote unquote, complying with this quote unquote regulation, but really remembering that, as Nick had spoke to this, that NCAP is really about accuracy in data, linking in data, and kind of the Bureau's response to some of those pieces that were brought to their attention via this settlement. That being said, all of you in the industry obviously have a responsibility to be prudent when it comes to the loss of this data in regards to how it's going to affect your business, how it's going to affect the credit quality in your portfolios, and then subsequently how that credit quality in your portfolios is obviously going to affect your income statements. We all know that this data, this lien and judgment data, has been used in credit decisioning for decades. And that, of course, is due to its predictive power. it being removed from the bureaus is in no way reflective of a lack of merit of this data. Kind of moving on, our research shows that consumers with a lien or judgment record are twice as likely to default as those without a lien or judgment. And this statistic looks at the presence of a lien or judgment record, whether it's been satisfied or not. Just the fact that it was reporting under the consumer's record at one point in time makes that person statistically twice as likely to default. When we look at the size of that lien or judgment, that gap in credit performance between these two populations, those without liens and judgments and those with liens and judgments, that gap grows even larger. Looking at the number of consumers that we have when we did this research, looking at the number of consumers with a lien or judgment record, we're talking 25 million consumers here. And so when you look at that as a percentage of the U.S. population, that could say that if your borrower or your applicant set reflects the U.S. population, that upwards of 11% of your applicants might have these kind of records, and also that your view on that 11% of applicants could be narrowed starting next week. And then for some of you that have portfolios that are not reflective of the U.S. population in general, the percentage of applicants in your pools, in your lines of business, may be much larger than that, meaning that effect could be even larger. Now, I think that a lot of the focus in the media has been around score migration due to this data removal. And I know that we've all heard a lot of different things, but I think the general line that we've been reading is that there's not going to be a whole lot of score change overall when we look at the entire population. And so our focus has really just been in looking kind of beyond what the effects are as far as the score goes. And I know that many of you are in the school of thought that there will be other negative factors reporting on the consumer's file that will compensate for this loss of data, kind of leading indicators that happened in the consumer's trade line long before the lien or judgment ever appeared. But just one of the things that's not considered in this school of thought is civil judgments that aren't associated with the trade line at all. There could be payment obligations tied to civil judgments or even state tax liens that will no longer be reported by the bureaus and really could affect your debt load calculations and then create other blind spots in the data as far as your view of the consumer goes. So moving it on, we're going to have another poll question here.
Great. Thank you, Zach. Yep, so as promised, here we go. Second poll. Another yes or no question. Do you have rules written around liens and judgments in your underwriting workflow? So another yes or no question, as I said, and give everyone just a moment to ponder this question. Once again, do you have rules written around liens and judgments in your underwriting workflows? So I think that's probably about enough time for everyone to make their selection here. So, okay, I'm going to go ahead and share results. And there we go. So even, yeah, so 76.5 say yes, and about a quarter of you say no. So interesting. And let me turn things back over, I believe, to Zach.
Yep. Yeah,
okay.
Thank you. So yeah, I mean, I think this is kind of what we would suspect, and what we've also been hearing out there in the market. That many of you have seen the predictive power of liens and judgments, acknowledge the importance of this data in your underwriting workflows, in your scoring models, that this is an important piece of predictive data around consumer behavior. 77% are saying that this is in their model, which leads to my next point of just really thinking about what are the impacts beyond the score. I know that some underwriting rules or models look for the simple presence of these records, and it could possibly trigger a kick out of the loan or possibly manual underwrite. Some rules look for a lien or judgment over a certain dollar amount and then decline or refer the loan for a second look. And so, obviously, just further evaluation of your lending policies, your underwriting workflows, your scoring models, to make sure that we've looked at, for in every nook and cranny for where the loss of this data may affect your business. Another facet that we've heard a little bit about out there that's gotten, I think, by far less consideration is some exposure for those of you that do collateral secured or cash secured loans. So looking at these deposit secured loans, it could be detrimental in some of these to not have visibility into a lien or judgment record that could blindside you with a levy somewhere down the line. I know that a lot of folks use these cash secured loans to help consumers build credit, and so a lot of times it's someone who has either a thin file or maybe no file at all that's trying to establish some trade lines. And if we don't have visibility into whether these folks that have very limited credit have liens or judgments, that could open us up to some loss in the form of collateral exposure. Similarly, for those of you that have the right of offset written into your lending contracts, a lot of times the deposit in an account that is also at your institution can be used as a compensating factor in the underwriting decision that you made. And again, a levy comes along that was tied to a lien or judgment, and you were not able to anticipate that because you didn't have that data out there. You could end up with a borrower that has no reserves left in their checking account. You may have used the fact that you had your direct deposit coming into that account or other streams of income coming into that account that were part of the basis of your underwriting decision that was made in a more manual manner, and now with this balance in this account being wiped out, the chance of this borrower making that next payment goes down. The chance of this borrower defaulting obviously increases. So we're just really encouraging you to take a well-rounded look, kind of into the nooks and crannies of all the pieces of your business that are using this data, knowing that it does hold predictive power, and that it is very indicative of a consumer's future performance. So now passing this back over to Nick for some further insights into the real estate lending world.
Thank you, Zach. Let me do this. There was a question about what are the data components that the bureaus are using as part of their NCAP settlement to include records on the credit reports. As I mentioned on the prior slide that I spoke on, around July 1, the bureaus have said that that's not a hard date, but around July 1, records will only be included if at least 3 of the 4 personally identifiable pieces of information are included, and that includes Social Security number, name, date of birth, and address. Now, transitioning over to what we see as impacts to the mortgage industry, we're going to talk about 3 key components that we see that the industry is going to have to look at. First off, clearly the conventional mortgage market has gravitated to relying on automated underwriting systems. That obviously means Fannie Mae's desktop underwriter and Freddie Mac's loan product advisor. And clearly they've brought a tremendous amount of speed and consistency in processing and responding to applications that are submitted. But one thing that is worth reemphasizing here is that both of the GSEs, Fannie Mae and Freddie Mac's seller servicer guides, or their guides, really hold lenders as ultimately being responsible for the accuracy of that loan data that's used by the automated underwriting system to consider the loan. More specifically, that if lenders have additional information, they're expected to act upon it. And specific to liens and judgments, there's a couple areas why those records matter. First and foremost, the guides stipulate that any lien or judgments that are on a payment plan or any sort of payment plan of 11 or more payments, regardless of whether they show up in trade lines or not, if the lender is aware of a payment plan of 11 or more payments, that's supposed to be factored in to the debt-to-income ratios and obviously the ability to repay test. And then the guides are also consistent between Fannie and Freddie that any items out there like liens or judgments that affect the position of the loan that's in process in terms of when it gets recorded, what lien position it will be in, or if this open lien or judgment record affects the borrower's equity position, those are expected to be paid off at or prior to closing. Those requirements don't go away. So both in terms of the ratios and in terms of compliance, those are key considerations to think about. Let's go over to a poll question, Mike. Do you mind?
Great. Thanks, Nick. Absolutely. All right. Let's put this next one up here. Okay. Is the focus of a preliminary title report to identify liens or judgments about an applicant, subject property, or both? So there you go. Your three selections here are applicant, subject property, or why does it matter? So everyone weigh in on that one. Once again, the question is the focus of a preliminary title report to identify liens or judgments about an applicant, subject property, or both? Okay, that's probably enough time for everyone. And let me share results. And there we go. So subject property, 72%, applicant, 22%, and you had 6.1% of you saying, why does it matter? So, Nick, were you going to weigh in on this?
Yes, please. Thank you.
Okay, great. Please.
So I think there's relevance in asking this question, especially we'll get into some of the announcements that have come from Fannie Mae and Freddie Mac recently, but we've certainly heard from conversations with our customers that there's an expectation that they can rely on the title report and the preliminary commitment that comes out of that. And I think it's worth clarifying here that a title policy ensures a clean chain of title, especially from the last seller to the pending buyer if it's a purchase transaction, or the current owner of the property in the case of a refinance. And that further, that title insurer will step in if there's any contested ownership claim. So really that's the fundamental purpose of that policy. And so the research that they conduct as a precursor to issuing a preliminary commitment, or ultimately issuing the policy, is they'll focus on liens and judgments that are tied to the property address first and foremost. The research will obviously look at the names of the parties involved and see if there's any potential impact there. But when you think about doing research on the names, the title company's ability to overcome the limited personally identifiable information remains an issue for them as well. So let's go into, Mike, do you mind?
Yep, absolutely. The next question here. So based on Fannie Mae's recent lender letter, are lenders still responsible for determining borrower liabilities? And here's a yes, no, or don't know options here. And that letter number is LL21702. So based on Fannie Mae's recent lender letter, are lenders still responsible for determining borrower liabilities? Okay, everyone, give you just another moment or two to make a selection there. We'll bring Nick back in. Okay, let's just go and share at this point. So yes, 81.3 by far and away the highest selection there. Nick, what do you make of those results?
So thanks, Mike. So I'm glad to see that it was so heavily skewed that way, and certainly we kind of alluded to it earlier, but it depends on how closely you've looked at some of these announcements. But we've seen that many have looked at Fannie Mae's announcement, the lender letter, and come away with the understanding that desktop underwriters' view of liens and judgments, which, by the way, will continue to be fed by the credit data that they receive from the bureaus, is all that matters. However, if you go a little bit deeper on their lender letter and look at the top of page 2, the headline there on that second page states that the lenders are still responsible for complying with 2 key guide sections. Section B3601, which gets into identifying liabilities, and again, the ability to repay analysis. And we'll talk about another guide section later, but a key point here is that Fannie has also reserved the right to monitor the situation and potentially change their position. And when you look at, Zach spoke to a stat that in a broader consumer finance perspective, that 2-time default risk, well, we've done some analysis specifically looking at mortgages, and the power of the lien and judgment as a risk indicator in and of itself is 5.5 times higher indicator of a default risk than consumers who did not have liens and judgment data. I think that's a key point to consider. And that's really consistent with why their guides list bankruptcies, foreclosures, deed in lieu, liens and judgments as a significant credit event that requires the lender to take a deeper dive. And the more recent that event, the more significant that is in terms of the ultimate decision on that application. Now, Freddie Mac, subsequent to the Fannie announcement, they issued some communication, and their announcement was similar in the sense that they stated that lenders can rely on Loan Product Advisor, and that there aren't any changes to the requirements planned at this point. And that, just like the Fannie Mae front page announcement, ultimately they're not requiring their lenders to get any additional information regarding assessments or the supporting documentation, except Freddie did add that thin and no-file consumers, that's still applicable. And they cite their guide section 5201.1 as the area where you can go to get more information about that. I would argue that the thin and no-file or any refer that comes out of the automated systems actually is subject to the need for this additional documentation. So if there's a key takeaway here, the announcements that have come out, lenders may have read this and said no additional information is required, but if you look at it closer, there's actually instances where it absolutely is required. And to make that more interesting, FHA has recently reaffirmed that their lenders, that the lenders who are processing an application for an FHA loan, they absolutely remain responsible for complying with the HUD handbook. They cite 4000.1 as the handbook version, and any relevant guidance. So and they're not issuing any mortgagee letters to clarify further. So barring any other information specific to FHA loans, lenders absolutely are still on the hook to identify any liens or judgments as part of processing that application. So let's finish up on what we see as changes that will be detrimental to the industry. So we've already talked about earlier through the poll questions that the lenders remain responsible for the information that's fed into the automated underwriting systems, specifically around making sure that the debt ratios are correct and that they identify any items that need to be paid off prior to closing, right? Now the question is, if you don't have that additional information, how do you remain compliant with that section to make sure that, for example, the ratios are correct? Now, let's get specific to the closing delays. So regardless of the type of loan that you're looking at with an application, I think all lenders will agree that time is of the essence when it comes to identifying everything that needs to be done between the time of application and closing. And when an item like a lien or judgment is discovered, the lender has to go through a process to identify whether that record actually pertains to the applicant, verify whether that record is open and relevant, and if it is open, they potentially have to factor that into the closing documents, specifically the HUD-1. And so obviously the later that lenders find this out, the higher chance that it jeopardizes the closing dates. And I think we're all pretty familiar with how important it is to try and make that closing date happen as scheduled. Mike, will you lead us into a poll question, please?
Absolutely. Happy to. All right. Oops, sorry about that. Ahead there. Okay, so are lenders still responsible for identifying delinquent credit to be paid at or before closing? And it's another yes, no, or don't know question. And let me just wait a few moments here for everyone to chance to mull that over. Again, are lenders still responsible for identifying delinquent credit to be paid at or before closing? Okay, that's probably enough time here, so let me go ahead and share the results with everyone. And yes, 93.5% of you say yes to that. So I hear a chuckle on Nick's part.
Thanks, Mike. Well, really, this was a question just to test to see if people were paying attention to the slides and the commentary that we've just provided earlier. Clearly, if you look beyond the headlines of the announcements that Fannie Mae and Freddie Mac have issued, clearly lenders are still responsible for identifying those and making sure that if they affect the lien position or the equity position of the borrower, that those get paid off at or before closing. So, we talked about it in the other poll questions, and we've reiterated that their statement has said that no additional information is necessarily required, and yet in the case of thin, no-file consumers, or if you're working on an FHA loan, you actually are still responsible for identifying that information. And regardless, when you look at the Fannie announcement with the ability for them to reassess that situation and potentially issue an update, really the key question for you right now is, these policies still apply, and if they do change their position, how do you ensure that you've got a comprehensive view of liens and judgments, and what's your plan to remain compliant with their requirements, both when the credit content changes and if the GSEs issue a subsequent update? So especially if the time of, like, for example, the lender letter that was issued mid-June, and if they go down the road and say, you know what, no, we do think that this information is more broadly necessary, what risk does that impose on you for the loans that have been originated in the time in between? So, Mike, actually, I think we're going to transition over to Jason to talk about the impact of collections, but if you would, please start us off with a poll question.
Okay, great. We'll do. So here we go. Does your collection score utilize lien and judgment data? And possible selections here are definitely, I'm not sure, or no. And in just a moment or two, we'll bring Jason into the discussion here, and he'll take us along. But just give everyone another moment or two to answer this question. Does your collection score utilize lien and judgment data? Okay, that's probably enough time. Let me go ahead and share results. And definitely, 54.5 you say definitely, 35 say you're not sure, and 10% say no. So interesting results there. And Jason, let me ask you, are those results you sort of expected to see, or were any surprises there?
Well, hey, thanks, Mike, and good afternoon, everybody. The results of the poll question may be somewhat dependent on who you have representing your company on today's call. A modeler may know right off, whereas an operations manager may not. It's also dependent upon how transparent your score provider is or company is about disclosing model attributes. But from this poll, yeah, it is interesting to see that at least half of you know that for sure your model does include lien and judgment attributes, and for the rest of you, that's something to go back to the shop and look into. But what's important to note is scoring extends beyond front-end decisioning in mortgage and loan processing, which is what has received most of the attention. It's also a key to drive back-end collections and recovery strategies. Collection scores are used to segment, prioritize, allocate resources, and assign treatments. Scores can help make the decision about what should happen to each account in every stage of delinquency. Most collection scoring models find judgment and lien attributes to be predictive in regards to a consumer's willingness and ability to repay a debt. In a collection score, or if a collection score is currently using judgment and lien attributes from the bureaus, which there is a good chance it is, then the absence of those attributes will adversely affect the score. It will make consumers who have judgments and liens appear more collectible than they actually are. Their score will be artificially higher. So if your company is using a homegrown score with judgment and lien attributes from the bureau, or if your company is using an off-the-shelf credit-based collection score, then those models will need to be revalidated and potentially rebuilt or replaced. They can either be rebuilt without judgment and lien attributes, which will calibrate the model but may weaken its predictiveness, or preferably the model can be rebuilt with replacement judgment and lien attributes, or replaced altogether with a model that already includes them. Failure to act may lead to less collectible consumers entering treatment streams for more highly collectible consumers. This miscuing of accounts may cause resources to be wasted and efforts to be ineffective. Collectors also rely heavily on judgment and lien data to make sound suit decisions. This data is often overlaid with a score to help make decisions about whether or not to sue a consumer who is unwilling to make a voluntary payment. Now, savvy collectors know that a consumer with multiple judgments is less likely to yield the same results as a consumer with no judgments or liens. In which case, a consumer who meets a score threshold for filing suit may be disqualified due to the presence of multiple liens and judgments. Collectors also find it helpful to evaluate the type of lien and judgment, the amount, the recency, etc., to inform their decision to litigate or not litigate. Litigating, it's a costly proposition, so making fully informed, upfront decisions can make the difference between satisfying your new judgment and just growing a portfolio of non-performing judgments. The goal is to sue more accounts that lead to satisfied judgments and to sue fewer accounts that would have otherwise led to a dormant judgment. Historical judgment and lien data help make this possible. Many have come to rely on at least some of this information being available as part of a credit attribute package or as part of the credit report itself. So to maintain the integrity of the legal decisioning process and to evaluate consumers' voluntary willingness and ability to pay, collectors will need to use a new source for judgment and lien data. Okay, Mike, let's move on to another poll question.
Excellent. All right, here we go. How do you reconcile the status of judgments in your portfolio? With the credit bureau, from the courts, from the litigating attorney, or the need to reconcile? 4 different possible answers on this one. How do you reconcile status of judgments in your portfolio? All right, everyone. Hopefully you've had about enough time to answer this one. I want to leave as much time as possible for some questions at the end here. So I'm going to go ahead and share these results now. And there we go. So credit bureau, 37.1%. From the courts, 34.8%. And those two were definitely the top selections. Jason, what do you think of those?
Well, I think the poll results at least indicate that most of you have attempted to reconcile these types of judgments and liens in your portfolio. I imagine that any company that has needed to perform some sort of reconciliation has tried lots of different approaches, including using data sourced from the bureaus, going directly to the courts, and collaborating with the attorney of record. Whatever the method, you've probably seen mixed results, probably leaving you with a feeling of kind of being uncomfortable with the final outcome. That's my guess and my experience. Now, these reconciliations, cleanups, and validations are often one-off special projects, not part of daily operations like the first 3 use cases I discussed. The use cases that I have listed here seem to be problems that are somewhat common and a source of real frustration for creditors, debt buyers, and consumers. I've known debt buyers to perform arduous manual validations on newly purchased portfolios that lack sufficient documentation of the judgment status. I've also seen large banks warehouse entire portfolios of judgments because they've lost confidence in account status. The debt buyer example significantly increased the cost to collect, and the bank example forewent the opportunity to collect hundreds of thousands of dollars. These can be difficult and costly problems to solve, but they certainly are not problems to be ignored. Solving them can lead to increased liquidation rates on accounts that have already been highly invested in. Solving them can also help mitigate regulatory risk and better serve consumers. I hope that Nick and Zach and I have helped shed light on the pending change and how that change will impact these 3 key markets. If this change is new to you, you may feel overwhelmed as you process the effect on your company. But even if it's not totally new to you, there still may be unanswered questions about what to do next. We'll use the remaining time to share some recommended next steps and field any questions you have to help better navigate this new environment. I'll start with collections and then pass it back to Zach and Nick. So beginning in July, this change is happening whether companies are prepared or not. If your company hasn't already, it needs to ask itself, what immediate and longer-term impact will this change have on my collections operation? And how can I use this opportunity to improve my collections operation? I recommend taking the following next steps. Number one, identify all areas of your collection business currently leveraging lien and judgment data. This would include collections and legal scores and decisioning processes for filing suit or assigning other treatments. This may also require evaluating third-party law firms and collection agencies that support your strategy. Number two, identify all areas of your collection business that could benefit from using lien and judgment data. This may include the aforementioned, but your company may also need to reconcile or clean up a portfolio. Number three, implement a plan to source, test, and replace lien and judgment data needed to fill all workflow gaps so collection outcomes can be optimized. LexisNexis has solutions that can help with revalidating, rebuilding, or replacing collection scores. We can also help by providing data for various workflows and cleanups. Whatever judgment and lien gaps you have in collections, we can help with FCRA compliant, reliable, and comprehensive solutions. Three things that we'll touch on further before we wrap up today. Now, let me pass it on to Zach for his recommended next steps for lenders. Zach?
Great. Thanks, Jason. So yeah, just to reiterate a couple of the points that we touched on earlier. Obviously, just need to take a close look at underwriting workflows, lending policy, looking at those pieces that directly look at the lien and judgment records. Remembering that your view into the consumer's debt ratios and willingness to pay is going to change starting next week. Then secondly, just considering the event of a levy due to a lien or judgment that you didn't have prior knowledge of, just considering what effect that would have with both your cash secured loans and your right of offset. And finally, and most importantly, just finding a way to replace this incredibly predictive data with records that can be linked accurately. Our RiskView Liens and Judgment product can restore your insight into this very predictive data and help you avoid blind spots and restoring a holistic view of the consumer. Remembering that this product is FCRA compliant, and so everything that comes with that, including customer dispute centers, our consumer dispute center, everything like that is supported. So with that, I will pass it on to Nick for his wrap-up.
Thank you, Zach. So specific to the mortgage space, in terms of what we see as recommended next steps, the first point that we emphasize is that lenders should be looking at an FCRA solution to address the upcoming change from the content of the credit reports. And while it may be available and tempting and maybe even convenient in some instances, we highly recommend avoiding the use of non-FCRA data in lending. And what drives that recommendation is a recognition that there's a consensus of legal opinion forming among large financial institutions, many of whom may be involved in the wholesale or the correspondent side. And LexisNexis shares this opinion that the use of a non-FCRA data or report to decide whether to subsequently run an FCRA report or to kick off an FCRA process is already an FCRA decision. That's a key point. What that means is that making the decision using non-FCRA data actually puts your company at risk for being out of compliance with the FCRA. Using non-FCRA data anywhere close to the underwriting credit decision process is dangerous at best from a compliance perspective. Second point, obviously we believe that you need to look at a solution that is reliable and that any solution provider out there who is benchmarking their solution to what the credit bureaus currently offer is certainly not good enough going forward. And really that's the basis for part of the NCAP solution around the liens and judgments treatment. So it's important to recognize that the credit bureaus are dropping that lien and data as a result of an NCAP settlement, and so any content provider or solution provider who is calibrating their performance around what's on reports today is not a great starting point for you in terms of going forward after July. Obviously, you want a solution that's fast and comprehensive. You want to be able to do a search that covers the entire U.S., that if an applicant has moved from one state to the other, that your search is going to pick that up. And obviously, as we talked about earlier, in terms of being able to identify any of these items to minimize any impact to your closing date, you want the results fast. You want it accurate, you want it comprehensive, and you want it quickly, and certainly you want an FCRA solution. Mike, I think we're at this point, I think we've gone through covering the impact assessments for the markets. So I'm going to transition it back to you so we can go over addressing any questions from the attendees.
That sounds great. That sounds great. And I'm going to put just as we get into that, I'm going to go ahead and put up this just last little poll question for folks to let us know if you would like LexisNexis to contact you. And yes, we've got lots of great questions here, lots to get through. So I will try to be brisk in my reading here. Okay, the first one, let me ask Zach, can LexisNexis support consumer disputes of these records?
Perfect. Yeah. So just like I had mentioned before, that this product is FCRA compliant. It can be supported, or it is supported through our Consumer Disclosure and Dispute Center, which, just like our RiskView product and the other scores and attributes involved there, can be accessed by phone, written correspondence to dispute this information. And we actually offer unlimited inquiries for consumer files. And then, of course, if there's anything on there that the consumer finds to not be accurate, we could handle that inside our dispute center.
Excellent. Thank you, Zach, for elaborating on that. All right. Nick, what method does LexisNexis use to accurately match consumers with L&J source data?
Okay. So reliability in terms of matching the consumer to a liens and judgment record is really a combination of LexisNexis leveraging our proprietary linking algorithms, our cutting-edge big data technology, and our vast data resources. The end result is a linking technology that uses analytics and machine learning to avoid both false and negative positive results. Avoiding both false positive and negative positive results, delivering a highly reliable linking outcome. And unlike other sources who use hardwired or rules-based linking technology, because of the diversity of the data that we have, we're not as reliant upon having those the three of the four pieces of personally identifiable information. And it's worth noting that specific to the liens and judgments issue, we've actually conducted two different studies to test this. In the first study, we took a sample file of around 26 million records and ran through how we assigned those records to consumers with and without the Social Security number data. And what we found as a result of that study is that the assignment or the linking of those records changed no more than 0.1%, or to restate that, 99.9% of the linking remained unchanged. So that's to demonstrate that we're not as tied to Social Security number. The second study that we did, we took 500 liens, 500 judgment records, and we had a team of our engineers who have extensive linking expertise review the source record, the lien or judgment record, and the assignment that we made using our linking technology to confirm whether that linking was appropriate. And the result of that study, we determined that over 99.7% of the assignments were reliable. So our position is that these two studies reinforce our conclusion that our customers can rely on this data to make informed and confident fact-based decisions. Mike?
Excellent. Thanks, Nick. And sort of another L&J question here. How does LexisNexis source and compile the L&J data?
So, Mike, I'll pick that one up. This is Nick again.
Yeah.
So I alluded to it in looking for a solution that's national and comprehensive. LexisNexis collects public record data from over 3,000 counties, boroughs, and parishes in the United States, which, based upon census data from July of 2015, represents over 98% of the population. Now, that data is collected from each jurisdiction at least every 90 days, with the majority of those visited on a monthly basis. And on top of the data collection efforts and the data quality testing tools and processes we have, we also utilize a collection performance management tool to identify any potential sources to data latency. Those could include delays within our data collections network or our direct collection of that data, or even from the government reporting sources themselves in terms of lags of them being able to report the data. So the combination of our data collection efforts, our tools, and our processes, we believe, results in a broad set of data, including the liens and judgments that are both current and reliable. Mike?
Excellent, thank you. All right, here. And here is a question, I think for Zach, but anyone please just jump in. Please repeat the data points and how many must match to be included in the credit report.
Yeah, and I guess, and Nick could elaborate on this as well. It's not the difference here is that our linking technology, we have a technology called SALT, Scalable Automated Linking Technology, that is much more robust than just looking at a few pieces of PII. Because we have such broad coverage on the public record data world, we can use multiple different data touch points to be able to kind of triangulate and figure out who this person is based on more than just social security number and name. And a lot of times, all we need is a name and address to be able to get that match. And like Nick had mentioned, with that study taking the social security number away or having it there, the change in our ability to link those records was negligible. And we do actually have a white paper published. I don't think there's an external link out there for it yet, but that should be soon to come, that goes into detail about how we link these records, how we source these records. It's about a 5 or 6 page white paper that really can offer some insight on the linking side of this.
Excellent, thank you. All right, what is the date that this goes into effect?
Mike, this is Nick. The bureaus have stated around July 1. I don't believe it's a hard date. I think they've allowed for some flexibility, but they've basically said starting July 1, that's when you can start to see those content changes on credit reports.
Great. Thanks, Nick.
Yeah, and of course,
Nick,
since this isn't regulatory, this is, they're making this change themselves, putting these dates out there themselves, the bureaus, and so keep that in consideration.
All right, good. All right, next question. I have heard that bureaus are saying this change will not have a significant impact on FICO scores. How do you interpret that statement?
Yeah, I can take that. I think that there's some good there are some publications out there. I know that Vantage has a white paper out there talking a little bit about some of the some of the research that they have done around their scoring. And the bureaus, from what I've read, they're making adjustments in their models to look at other, kind of like we had talked about earlier, some other predictive or leading indicators, and shifting some of the weight off of these records that are going to be lost onto some of the other records. But there's still going to be a big hole there as far as the gaps of not knowing what these records are. Payment streams that aren't tied to trade lines that are going to cause issues with debt calculations, and then also, the items that I had mentioned about right of offset and things like that. Do you have anything to add to that, Nick?
No, I don't.
All right, great. Let me just jump into the next question here. All right. Have you received official notice from FHA or VA on how these changes will be reviewed?
Hey, Mike, this is Nick. I mentioned that lenders who have contacted the FHA recently on this specific topic have been given a very concise statement that really the lender requirements have not changed. They refer you to the HUD Handbook 4000.1 and any subsequent relevant guidance that they've issued. They don't plan to issue any new mortgagee letters on the topic. So ultimately, the lenders are to conclude right now that specific to FHA, they're required to identify these.
Gotcha. Thank you. All right, we're getting just about the top of the hour, but let me just ask one more question. Are you allowed to deny a loan based on information obtained on GLB or only FCRA?
Zach, do you want to speak to that generally, or do you want me to go into the mortgage side?
Yeah, go ahead.
So ultimately, the deciding factor on this around what data can be used really all apply, but the FCRA is the key part of how we've structured our service around this. So we have designed this product to be FCRA compliant and to really adhere to a lot of the components of NCAP as it relates to accuracy and the timeliness and of the data. So I'll just use that as the answer to the question for now.
Yeah, and we were sorry, I was on mute when the question first got asked there, but yes, you are only allowed to make a credit decision based on FCRA data. GLB data is for screening for fraud.
Excellent. Excellent. Thank you. And we're just, I think that's a good note to wrap up on. We're just about a minute past the top of the hour, and we always do like to bring these in as close to schedule as possible, respecting everyone's busy days. But let me first of all thank Zach and Jason and Nick. It's been a great hour of discussion. We had some lots of great content, of course, and then lots of great participation in the polls and lots of questions from the audience. So thank you all for asking those questions. As I mentioned at the very start, we will follow up with everyone's question. We will follow with everyone who we did not get a chance to address your question with us today. There were a lot of questions, which makes us feel very good, actually, that what we're talking about here is resonating with you. So thank you for being here and participating. And also, please keep an eye out. We'll be sending you an email in the next day or two that will have a link to the recording and a link to the actual slides themselves in PDF form. So that will come your way shortly, and you can review this material at your leisure in the future. We encourage you to do that. And with that, I will wrap it up. Wish everyone a wonderful rest of the day, and I hope you'll join us again here very soon. Thanks so much.